Good evening, everyone. I'm Jane Lawton-Cotel, founder of Eaton Fire Residents United, otherwise known as EFRU. We are a resident-led advocacy group collecting and mapping industrial hygienist test results from homes in Altadena, Pasadena, and Sierra Madre. We have three panelists tonight that I'm very excited to present. First, we have James Castle, founder of Castle Legal Group. He is a Georgetown law graduate and former deputy district attorney who later became a partner at a national firm defending major insurance companies. He now uses that insider knowledge exclusively to represent policyholders, with his firm handling smoke claims across California. Castle Legal Group is currently representing homeowners against Fair Plan, Farmers, AAA, USAA, and State Farm to secure fair recovery for smoke damage. We also have Kevin Pollack, who leads Axe Law's insurance bad faith litigation practice and has become a champion for wildfire smoke victims. He brings science into the courtroom using hygienist testing, lab analysis, and building forensics to prove contamination and force insurers to keep their promises. As lead counsel in numerous cases against insurance companies like Allstate and National Surety, Kevin has obtained groundbreaking rulings this year, exposing shallow investigations and demanding that insurers return people to safe homes and thriving businesses. And of course, we have Dylan Schaffer, who is a partner at the firm Curley Schaffer, which specializes in assisting property owners in disputes with their insurance carriers. He has a number of published California and federal opinions enforcing the rights of property insureds, including a June 2024 ruling from the Los Angeles Superior Court that Fair Plan's policy is unlawful as it relates to the treatment of wildfire damage. His practice is presently focused on assisting Fair Plan standing home victims. So the first question: how do California laws treat smoke and toxin-related damage compared to direct fire loss, especially for contents and structural claims? And I'll shoot this question first to Kevin.
Well, thanks, Jane, for the introduction. To answer the question shortly, they're not treated any differently. Under Insurance Code 2071, all loss by fire is recoverable under first-party property insurance policies. And the law is very clear that smoke is a byproduct of fire. And so all damages, all loss caused by and resulting from smoke is recoverable under a homeowner's insurance policy, no different than if a home had been burned to the ground.
Dylan, can you describe in a perfect world what the recovery process is for a homeowner in recovering their home after it's been impacted by smoke and ash, i.e., what is the three-step process of testing, remediation, and testing again? And why is that so important to have that three-step process?
So fire causes three kinds of damage. It causes thermal damage, which we all know about and can see, but it also causes chemical damage, which can impact building components like roofing and electrical systems. But then it also causes what I would just describe as contamination damage. This is what we're talking about here. So this is not damage that necessarily results in the deterioration of building components. The insulation might still work, but you don't want to have a bunch of lead and beryllium in your insulation because it's going to make you sick. So the way to approach that after a wildfire is to get a competent, unbiased, and environmental investigation. And whether that's a hygienist or some other professional, there's a variety of licensing and professionals that work in this field. But the good ones will test broadly. They are investigators. They don't have a template, or they're not cookie cutter. They're investigators, and they will test broadly in terms of the contaminants they're looking for and where they're going. So where did it go and what's in it? Those are the two questions. So the good hygienists will look broadly, and then they will convert their findings as to concentrations and infiltration into fulsome recommendations for repairs. Now, the one gray area here is that hygienists are not specialists in building components. They're not contractors. So they should understand the impact or the potential dangers posed by wildfire contaminants on building components, insulation, drywall, flooring, and so forth, HVAC systems. But in the end, what they're doing is recommending repairs. And that is what it is. It's a recommendation. It is not a scope. And so what you want is to have a very good handshake between the hygienist or the environmental investigator and a restoration professional. I prefer somebody who's got a license and a truck, not necessarily somebody who is essentially a glorified house cleaning service. You want somebody who understands that sometimes walls have to go. HVAC systems have to go. Flooring has to go. Not always, but sometimes. And they need to be able to be licensed to do that work. So not just remediation, but restoration. Okay? And then the tricked clearance testing, meaning post-restoration investigation, is time. Because these houses can appear to be very clean the day after the work gets zipped up, and 6 months later, they're contaminated again. So I always tell people, run your HVAC system, give it a couple of weeks, and go back and then do some decent testing. And it's science. Either the stuff is back or it's not. And typically, if it's back, it's because the contaminants sit in reservoirs. The contaminants sit in building components that are reservoirs for partitioning recontribution into their living space. So you end up with contaminants in places like flooring and drywall and HVAC systems insulation, and because of equilibrium, it wants to come back into the living space. So if you do good post restoration clearance and your house is fine, you're in good shape. Otherwise, you got to go back and remove potential reservoirs. The one other thing to mention, which the carriers never want to talk about, but which is absolutely essential, is pack out of contents. If you have a house that is filled with soft goods, furniture, mattresses, rugs, carpeting, drapery, and you do your CertPro $90,000 remediation, and you don't pack out those contents, either toss them or remediate those contents, you've just wasted $90,000 because those are recontributors to the contamination.
Yes, and there's some discussion about the fact that soft goods really aren't recoverable, like sofas and upholstered chairs and mattresses, because there's no way to actually get inside and have them cleaned. We had some environmental engineers, as well as Dr. Andrew Welton from Purdue University and Eric Bollins from Lightbox the other night, who have studied over 200, 300 tests in the Eaton Fire and Palisades fires to come up with some new guidance on sampling and testing homes. And that is their recommendation that furniture and mattresses just are not recoverable, even though many insurance companies seem to push for that. Folks, you'll want to watch that in the EFRU speakers series, which can be found on the EFRU.LA website, and then go to resources in the menu and then click on EFRU video, and you'll find the speaker series there. That event is dated for September 24th of 2025. When a homeowner opens a smoke or wildfire debris claim, what obligations do insurance companies have under California law? Specifically, are they required to provide pre-remediation testing by a qualified industrial hygienist, or to cover the cost of remediation and to provide or pay for post-remediation testing to ensure the property is safe?
There's no such thing as an insurance claim. First thing, your obligation of an insured is to report damage, give notice of the loss. Upon notice of a loss, it's the obligation of the insurance company to conduct a thorough, fair, and objective investigation. I believe that the standard of practice in today's world is that in order to conduct a thorough, fair, and objective investigation, environmental investigation by unbiased, licensed professionals is necessary. As Kevin suggested in his in the prior answer, certainly the costs of restoring homes to their pre-loss condition is covered for fire, and fire includes damage from fire contaminants and chemicals. It's certainly all policies require restoration to a pre-loss condition. So yes to environmental testing, yes to coverage for restoration, and certainly the carrier should be paying for both of those under the policies.
Thank you. How does a policyholder who opened a claim deal with repeated adjuster changes or an adjuster who does not respond to their claim needs for weeks or months on end? James, would you like to handle that question?
Yeah, and we're seeing that a lot when people call me and talk to about their claim. We're seeing that a lot. When people start to submit their original information, their damage information, they get bounced to a second, third, fourth, fifth, sixth adjuster. And I understand it's incredibly frustrating for people. I think this suggests the best advice here. Can you force them to have one adjuster handle your claim? No, they can do sort of what they want. Whether that's fair or not is certainly another question. And I think what you need to do is really sort of keep a timeline, a document where you talk about what you submitted when, what they've told you on the phone, and just really keep a diary of everything that happens. And then later on, if you want to take legal action, it just gives the lawyers such a head start in able to really assess what happened, why it's happened, and how best to sort of get the ball rolling with the litigation or assist you in sort of getting, establishing what is insurance bad faith, which I'm sure we'll talk about later, where those sorts of repeated delays and switching back and forth, it really goes to the bad faith question, and it can get you a lot of additional damages down the road.
Next question. What remedies are available to a policyholder when insurers delay or deny ALE payments? Kevin, would you like to handle that question?
Yeah, so I think there's sort of two different sides to that. There's the practical side of, what does a policyholder do during the claim process when the insurance company is refusing to pay ALE? And I think, unfortunately, because the insurer has the power of the purse, so to speak, they're the ones that hold the monies and the funds. The only thing that one can do is document it, as James suggested, and write those emails and write those letters, creating a paper trail, indicating the difficulty that the insurance company is creating, identifying that the home is not habitable, identifying that the home is not usable, identifying that there's a disagreement over the scope of repair, all of those things that would trigger one's rights to additional living expense, to show that the rights have been unreasonably withheld. With respect to what the right is, one obviously can pursue legal action for the breach of a contract, because the wrongful withholding of additional living expense is no different than the wrongful withholding of monies due and owed to repair or restore a home. And so ultimately, one has a viable claim against their insurance company for breach of contract and potentially for bad faith as well.
Okay, thank you. Next question. What remedies are available to a policyholder when insurers deny covering industrial hygienist testing? I'm going to relay this question over to James.
Yeah, so like we've been saying, they have a duty to investigate. You need to, again, document it, write emails. To the extent you have a single point of contact, an adjuster, you can escalate it to a supervisor. I haven't seen too many instances where they're not going to conduct any testing. It's really going to come down to an argument about what testing they pay for. And in this realm, there is good testing and bad testing, and then terrible testing, essentially. And what the insurance companies are paying for is very, very limited. And I think you need to have the knowledge of, most likely, you're going to have to go out and get your own certified hygienist who will do not just sort of the basic soot testing, but also the much more advanced testing where They're looking for all the heavy metals, including lead, beryllium, and those types of metals, as well as more invasive testing. So where they look in the attic and look in the insulation and drill behind the drywall, look at sort of the type of hardwood floors you have and see if, whether those things can be remedied or not. And that type of testing, it can be expensive, but in most cases, it's really going to benefit you probably to get your own testing. And then you can push back against the insurance company to really show that your results are much different than the results that the insurance company received from their testing company. And you can sort of really put it to them about what type of restoration is needed.
Dylan, can you speak to why it's important to understand how an insurer-selected industrial hygienist differs from a policyholder-selected industrial hygienist? We just heard James talk a bit about the fact that there are some industrial hygienists that do better practices in testing than others, and that you may want to look into hiring your own rather than an insurer's industrial hygienist. Can you talk a little bit, Dylan, about the key differences between these two scenarios and what implications they have for the policyholder, in so much as who is actually the client in these two different scenarios?
Well, the insurer's vendor is the insurer's client, or is the client of the insurer is the client of the hygienist that they hire. So, and many of these hygienists are folks we've been seeing for 15 years. They are deliver repeat business to the main retail carriers, and we've seen them over and over and over again. And I know Kevin and I have deposed a lot of them, and they have a very uniform story, and their story is essentially that these houses are basically dirty and require some professional cleaning, as opposed to the sort of potential tear out and restoration that James was referring to. So it's absolutely essential that folks get their own environmental testing. The challenge is that for the first time in these fires, because of the economic opportunity offered, a lot of those vendors are also presenting themselves as available to consumers. And so what we saw when we started getting folks in, January, February, March, we started to see a lot of those same vendors providing services to consumers, which was new and troubling, because they're not taking a different view, but either in terms of the scope of work they're doing or in terms of their recommendations. So I think the answer is you get exactly what you pay for, and you have to be careful about who you choose. And it's absolutely essential that people understand that the vendors that are providing services to insurers are bought and paid for by the insurance industry. There's no pretty way to put it. These people will say whatever they want to make the insurance industry happy, and they have done for a very long time. The difference now is that because of organizations like EFRU and others, the data is going to start smacking them in the face. They are not going to be able to say the same sorts of things they've said historically because of the density of data that we now are going to have. Between our firms and firms like ours, we will have perhaps many, many hundreds and perhaps more than 1,000 cases. And all of those cases are going to generate data, and I know that your organization has done as well. So I do think that this is an inflection point for these folks, but they're not your friends, and they are highly biased in favor of the insurance industry.
So what I hear you say, Dylan, is it's very important to have a bit of background on the industrial hygienist before you hire them. There are industrial hygienists that are pre-contracted by insurance. You can hire them independently on your own, but their practices are such that they tend to be limited in scope. Certainly, if your insurance is sending an industrial hygienist rather than you being able to pick your industrial hygienist, the client is the insurance company and it is not you. One particular point to know is that if your insurance company sends their pre-contracted industrial hygienist, The difficulty is that when you want to see a copy of that test, you can't request it from the industrial hygienist. You have to get your insurance company to agree to send it to you. And they are, I believe, they have a responsibility to do that. But I know a lot of homeowners have had a hard time in getting that industrial hygienist test once it's been done from the insurance company. Whereas if you hire your own industrial hygienist and hopefully can get your insurance company to cover the cost of it, that the client is you, the homeowner, the policyholder. And you may find in those cases, as long as it's not a pre-contracted industrial hygienist who already has sort of limited scope practices fashioned by their work with insurance companies, as long as you're getting somebody who doesn't have that kind of relationship preset, you're likely to have more, let's just say, detailed recommendations for the recovery of your home. Am I correct in saying that, Dylan?
You are. You can absolutely get the report from your carrier if you make a request for it, or should be able to get it. I'm sure some of the carriers are resisting. But there's no doubt that you got to buy your own expert.
Thank you.
Before you move on, I just want to add, I think it is important in those instances, whether it be a hygienist or another vendor from the insurance company that they send out, that you do request their work product directly from the vendor. And if the vendor refuses, you also request it directly from your insurer. Under Insurance Code 2071, you have an absolute right to all claim-related documents, which are defined to include work product of vendors that are assisting the insurer to value the scope of damage of a home. And so you want to paper those requests, because when the insurer or the vendors refuse to do so, that's only going to help your paper trail of your claim.
Okay, thank you for that. Next question. What rights does a homeowner have to seek an unbiased third-party industrial hygienist assessment? James, I'll relay that question to you.
Yeah, I think under the policy, they do not have to give you sort of your pick of a hygienist. So like we've been saying, I think it really is incumbent on you to sort of do your own research as to who really is independent. And then you are probably going to need to hire them and pay for that testing yourself. And then you submit that report to sort of to your insurance company to refute the insurance company's expert. And so that's how these things normally play out.
Okay, we'll move on to the next question. What are homeowners' rights when the insurance chosen industrial hygienist has limited remediation recommendations? And I'll relay this question over to Kevin.
So are you asking about a scenario where the hygienist that the insurance company retains doesn't actually make recommendations for the scope of repair, and then the insurance company brings in like a ServPro, and then you just kind of go about doing it the way that they want?
That is exactly what I'm talking about. Thank you for making it more specific. Yes.
So yeah, I think that that's a situation, to piggyback, what Dylan and James have been saying, is where you document that. You point out the flaws in the hygienist's report. You point out the fact that there isn't a scope. There aren't recommendations for someone like ServPro or Service Masters to follow. You raise those concerns, and then you bring in your own hygienist who brings to bear legitimate scope recommendations to follow, to show that your hygienist is the one leading the way. And to follow on an analogy that Dylan has said in the past, I mean, it's like a doctor trying to do surgery without imaging. How can ServPro go in there without the proper recommendations from the hygienist about what areas need to be remediated and how? They can't just go in blindly with a HEPA vacuum and some hydroxyl and go about their business, because as you will see, as you know, in your post-remediation testing that you're seeing, that doesn't work. And so by calling it out and bringing it to bear and telling the insurance company, your hygienist's report, while lengthy, doesn't really recommend anything. Like, as an example, I saw one this past week where they didn't address at all the air ducts. They said, oh, we didn't test in the air ducts. Well, okay, so how is ServPro going to address the air ducts? Are they not going to be addressed? Do they need to be addressed? And so you point those things out in the response letter that you would write to your insurance company where there are areas that they didn't test, right? Like something James said earlier. If they aren't going into the interstitial spaces of walls and doing core sampling, and you have concerns about that, and that's not addressed, that's something that you want to raise in correspondence with your insurance company. And hopefully your hygienist that you've hired will have addressed that so that you can bring, that power and that argument to the table.
Thanks for that. 2 quick comments. It's hard for people who are coming to this with no background, as many of us came in, hit with this fire and all of this smoke and ash impact on our homes for the first time. We had no reference point to understand any of these traps that occur with insurance companies to limit the recovery of our home and therefore the safe return to our community. But there are plenty of us who have been dealing with this over the last few months, and there's going to be new folks kind of coming into this situation, and hopefully they can learn from us. There's a couple of resources. There is Surviving Structures on Facebook, which is a terrific place for you to join if you have a surviving home from the fires and you want to ask people what their experience is. You can find that if you do a search on Facebook. EFRU has had some industrial hygienists come and speak in previous evenings. You can go to the EFRU.LA site and then go to resources and then look for EFRU video. And then underneath that, we have a whole speaker section, and you can look for where we have CIHs come and speak to our community. We'll also be hosting a industrial hygienist panel soon, I hope, with some new industrial hygienists that write lengthy recommendations. So keep an eye out for that. And then the last thing I'll comment on is that Kevin mentioned that EFRU will have, he mentioned that we review post-remediation tests, and EFRU has not put out that map yet, but we hope to in the next couple weeks. So the map that you'll see on the EFRU.LA site is a pre-remediation map. As mentioned previously, we have over 200 tests with 100% contamination throughout Altadena, Northern Pasadena, and Western Sierra Madre. That means every person who sent in a test has showing contamination in their home. It varies house by house, depending on how the winds carry the contamination and also what did that individual home test for. Not all homes tested for all contamination, but just because something doesn't show up in that home doesn't mean that it isn't there if they didn't test for it. So all of this information to say, keep checking the EFRU map, keep checking the EFRU speaker events, and more information will be revealed. We'll move on to the next question. Who is responsible for the cost of additional remediation if clearance is not achieved in post-remediation testing? And I'll relay this question over to James.
Well, the insurance company certainly should. So if there's hygienist reports and then some cleaning or remediation that takes place, who's supposed to pay if there's then testing that shows that it didn't work? Of course, the insurance company should. It means that their recommendations, opinions, their experts were wrong. And so the insurance company, under the terms of your policy and under the terms of California law and all the fair claim handling regulations, they're required to do that. They're required to pay. But we are seeing that that's not always the case. And so I've had several clients who got testing, or the insurance company got a hygienist out there, came up with a very limited scope of cleaning, hired someone to come out there, actually do the cleaning. And then they just closed the claim. They said, no more ALE, you need to move back in. And the homeowner doesn't trust that the cleaning worked. And they go out and they hire the hygienist to do another test, their own hygienist. And it turns out that the work wasn't at all successful. And in those situations, those are the cases where I think where they've closed the claim, shut you out, and aren't willing to pay for more testing or complete remediation. Those are really the cases where you're probably going to need legal assistance relatively quickly.
Not all post-remediation testing provides clearance, but you want to achieve that clearance before you return home so that you are returning to a home that is either contaminant-free or well below threshold for contaminants. Okay, well, let's move on to our next question. What obligations do insurers, including the California FAIR Plan, have to follow insurance commissioners' directives? Does filing a complaint with the Department of Insurance help the policyholder in getting their insurer to comply?
None. They have no obligation to do anything unless they get sued. And my experience is that filing Department of Insurance complaints is a waste of breath and time. And I generally advise people that it has no real, is of no real service in recovering benefits. If the Department of Insurance issues a cease and desist order, if it actually issues an order to a carrier, then yeah, including FAIR Plan, it's obligated to take action. I can tell you that the California Department of Insurance, after sitting on its hands for 3 years, did eventually issue a cease and desist order to FAIR Plan recently, and FAIR Plan's response to it has been to basically to ignore it.
Well, that's disappointing and frustrating for sure. Obviously, homeowners need to find other recourses, which is why we have you all here tonight. Next question. What recourse do policyholders have when insurers fail to comply with these directives or use tactics that delay recovery? Kevin, I'm going to relay that to you.
File lawsuits. I mean, Dylan's answer was short, and it's applicable here too. Like, until you file a lawsuit when the carrier has acted unreasonably and you've given them every opportunity to act in good faith and they've failed to do so, the only recourse that you have is to take legal action and gain the leverage that you need. Because in the claims process, the carrier has all the leverage. They can drag things out and delay things indefinitely. But in court, that's not the case. We have deadlines. We have trials.
I get asked every single day, many times a day, can an insurance company do this to me? Whatever it is. And the answer is yes. They can do anything they want. The only real recourse is in court. Unfortunately, the carriers have figured that out a long time ago, and they've made boatloads of money essentially denying or underpaying or failing to investigate claims because they understand that most people do not have the personal or financial resources to pursue their rights in court. But that is the one place, as Kevin identified, the one place where people are successful in asserting their rights. Otherwise, unfortunately, it's very challenging.
So, James, when does it make sense for survivors to consider lawsuits or join mass tort actions for smoke and toxin damage? At what point should they pursue a lawsuit?
I think it's like Kevin and Dylan were saying, it's when you hit that final roadblock, when you are beyond frustrated with the process, when you see that no matter what you tell them and no matter what testing you give them, they're going to take the same tact. They continue to delay. They continue to ask for more time. Oh, we're looking into that. And for the people who started their claim shortly after the fire, it's been 9 months now. And if your claim is still ongoing and you don't have testing completed and they're not paying for full remediation and restoration, it's time to start really seriously looking at hiring counsel, because every person that I've spoken to over these last few months, they are frustrated, but they're still trying to convince these insurers that they have a valid claim, and try to convince them to pay more and more money, and it just isn't working. So it's really unfortunate that lawyers and lawsuits are necessary, but it is absolutely to the point where you're going to need to pursue legal action when you are at that point of just being frustrated, delays, switching up adjusters every month, not getting straightforward answers, not getting callbacks. That's when you need to go ahead and hire a lawyer. Now, if the insurance company is doing an amazing job and you feel really pleased with your insurance company and they're doing everything you ask them to do, then great, pursue it, keep going. But I think that is not the case in most people's experiences. And it's unfortunate. These insurance companies, they're not unsophisticated. They know exactly what they're doing. There's statistical models where they see that, if out of 100 different homeowners, and they can delay and continue to sort of underpay and shortchange people, it makes sense to them financially over the long term. And the people who pursue it and the people who file lawsuits, they know they're going to pay those out. But overall, it makes sense for them to sort of delay things and see how many of you they can sort of weed out. And that's really sad, unfortunate. And that's why I decided I didn't want to work for insurance companies anymore.
Thank you. Kevin, how do courts view situations where insurers reverse previously approved scopes of repair or fail to honor documented industrial hygienist supported plans?
Won't take well to those. I mean, I see cases all the time where, during the claims process, the insurance company had documentation that supported a homeowner's claim, and the carrier did nothing with it. And then in the litigation, they'll hire someone to take a different position altogether. And while they may think that that's a smart tactic, it doesn't really play out well, because it shows an unreasonableness. It shows being, having a lack of objectivity and a one-sidedness, which ultimately plays into our hands to demonstrate why the carrier is acting in an unreasonable way, which ultimately supports a bad faith finding. As Dylan pointed out earlier, the insurance companies have an obligation to thoroughly, fairly, and objectively investigate and evaluate claims. And so if their investigation is one-sided, or they fail to consider evidence that supports coverage or supports a greater scope than what they've done, then ultimately that is going to be their undoing when we get into court. Because when they try to argue, look, how can we be in bad faith? We hired an expert. We relied on the expert. It's called the genuine dispute doctrine. We can undermine that doctrine by showing that they had a one-sided investigation, that they failed to properly investigate, and that genuine dispute doctrine is therefore unavailable to them under controlling authority in our state. And so, the short answer is the carriers that do that, they do that at their own peril.
Okay. All right. Next question. This one's to James. Are insurers obligated to continue covering ALE and related expenses during litigation, or only after a judgment or settlement?
So they should continue paying ALE, whether they will or not. The filing the lawsuit shouldn't affect your ALE, but it's possible that they will cut off that ALE and sort of take that hardline stance that they paid everything that they needed to pay, and then your house is safe. I think insurance companies might be a little hesitant to cut off the ALE just because it's going to make their damages in the lawsuit, whether bad faith or breach of contract, just that much larger, and sort of putting people to the choice of moving back into there's at least a dispute as to whether their house is safe to live in. So either the insurance company effectively forcing them back or making them homeless. I don't think that's going to play well with a jury down the line. So I think a lot of insurance companies will continue to pay the ALE while you continue to fight about the handling of the restoration and the remediation and the test results.
I will say that I have seen a lot of people very frustrated by the fact that their insurance company has said to them, you need to hire our contractor for the remediation of your home because we won't wait for you to find your own or wait for that individual that you're trying to hire to become available. And if you do not move forward with remediation immediately, we will cut off your ALE at the end of the month. What would you say to that, James?
Yeah, so this is starting to get into sort of positions of bad faith. They cannot force you to use their restoration company. If you're taking reasonable steps to find someone who's licensed and to do the work, and if there's some short delay in getting your person in there to do the work, they should continue the ALE. I think as soon as there's any threat of your ALE being cut off, that's another one of those signs where you need a lawyer to sort of put forth all those arguments in a lawsuit as quickly as possible to ensure that you're not put in that position of having your ALE cut off and having to make the choice of whether to move back into a contaminated home.
And Kevin, let me ask you this question. In these kind of situations where people are being threatened with their ALE being cut off if they don't use a specific contractor, or if they're in a situation where their insurance company is denying them post-remediation testing, which I will say there is two particular insurance companies that I'm thinking of that are across the board denying people any access to post-remediation testing in order to confirm whether or not their home is safe to return to after remediation. What is the likelihood that the courts will find in their favor if they seek litigation?
I mean, I think the facts that you're describing, obviously, in the abstract seem favorable to those types of claims. I mean, ultimately, as Dylan said early on, the basic obligation of an insurer in a property insurance claim is to bring the homeowner back to a pre-loss condition. And so if they're refusing to do post-remediation testing to ensure that the home is in fact safe and brought back to that pre-loss condition, then they're failing their basic obligation. Like, that's number one. If they're cutting off ALE prematurely and using threats, then that's, again, going to support legal claims for breach of contract and bad faith. The important thing that homeowners need to be aware of is in these situations, the best thing that one can do is to document the frustration, the disappointment, and everything else that goes with that, because the insurance company is keeping in real time their quote unquote claim file, and they're going to document things that are so far from the truth you would be shocked. And so the best thing one can do is to write emails, correspond, to create their own paper trail of what's actually happening in real time and why, right? To dispute the withholding of ALE, to dispute the early termination of ALE, to dispute the refusal to do post-remediation testing. That is how one is going to arm themselves for success.
Okay. And Dylan, how do statutes of limitations apply to prolonged displacement or delayed requests for assistance?
What I will say is that the statute of limitations that applies generally to these fires is pretty relaxed, because under the relevant statute, if there's a state declared emergency, the statute of limitations goes up considerably. That said, I think that the direct answer to your question is they don't really, there isn't an interplay between the amount of time you have to file a lawsuit and what the carriers are doing to you. The statute's the statute. So I would be, if you are a year into your claim, or, we're 9 months now. So if you're getting to be 9 months to a year into your claim, you need to get on the phone with people in this practice area who are competent and start talking about what your rights are and what the path forward is for you. It doesn't make sense to wait too much longer. My view is that these folks, meaning the carriers, were suable in February. They should have been out in January doing fulsome investigations and paying for repairs. To the extent that you're now in September and people are still fighting with their carriers, talk to a lawyer and do it soon.
Okay. One last question before we move on to some of our viewers' pre-submitted questions and some of the questions in the chat. The last question I have is, what should homeowners expect as far as lawyer fees in pursuing litigation? Do insurers, when they're found to be in bad faith, have to pay for your services for the policyholder?
When we come to agreements with clients, there's different ways we do it. There's one way of doing it where we just charge an hourly rate. And it does, when we get to the point of actually litigating a case and filing a complaint and then conducting discovery and taking depositions, it gets expensive relatively quickly. Now, at the end of the day, most of these cases are likely going to settle. But if you go all the way to a judgment, yes, there's going to be an assessment of attorney's fees only if there's bad faith found. So if a jury or a court, if a jury decides that, there was a dispute as to which expert was right, and it was the genuine dispute doctrine that Kevin was talking about earlier, then if it's just a breach of contract claim that gets awarded at the end, there's no attorney's fees recovery at all. So you're sort of destined to pay for your own fees. Certainly, when we litigate these cases, our expectation is that we're going to get recovery, whether via settlement or via a trial at the end. That includes some calculation for the attorney's fees. The other way that plaintiffs' attorneys handle these is on a contingency basis. So generally, I've seen, rates between a third and 45% of whatever's recovered goes to the attorney. And if you go all the way to the end of a trial, how that normally works is the court will sort of add on potentially money for the attorney's fees. And then per your agreement, all those fees sort of get lumped into a general pool of your recovery, and then that sort of contingency fee rate applies. So there's different ways to do it, but I think all of us would agree that when we are filing these cases on your behalf, we fully expect to get all your construction remediation costs for you, plus additional monies that will cover sort of the cost of your lawyer. So that is certainly all the goal for any plaintiff's attorney who is sort of pursuing these claims for you.
Kevin, just to add on to that question, I'm going to shoot this I know I said I was on the last question, but I think this is a clear follow-up to Jane's answer. Do you find that in litigation, insurance companies are penalized in any way for putting policyholders through this kind of secondary devastation and emotional stress in not honoring a safe recovery to their home? Is there any kind of penalty that insurance companies face, whether it be monetary in so much as they have to pay for emotional distress, or additional fees for not honoring the claims in a timely manner? I'm trying to get a sense whether insurance companies settle in order to avoid larger costly litigation, or do you really have to take it all the way to the end in order to get any kind of recourse?
Well, I mean, every case is different. Every insurer is different. They retain different defense counsel. So it's really hard to say in the abstract. What I can say is that in insurance cases, there are different buckets, so to speak. So first, you have your contractual damages, which are your contractual coverages and limits under your policy. So if you suffered property damage, depending upon the amount that the insurer paid and the scope of repair and the damage model that you've presented, there might be a delta. You're entitled to pursue that in court for personal property, for your home, for any withheld ALE, other structures, etc. So those are your contractual damages. And, to the extent that the insurer withholds those funds over a period of time and you're forced to go and litigate that, another thing you're entitled to is prejudgment interest is a claim that you can make, which is, interest on a claim for those contractual remedies, which by statute you're entitled to in certain circumstances. The other remedy, the other claim one has is if the insurance company's conduct was unreasonable by delaying, as you spoke about, or if they treated the policyholder unfairly, or they did anything, with their investigation that it was completely one-sided. However you want to slice it, if there's some unreasonableness in the claim, which is the standard, then the policyholder can, in circumstances, be entitled to various extra contractual damages. And those might include, as you referenced, emotional distress. So if the insurance company's conduct caused emotional trauma of some sort or another, then that's a claim one can make. There are also, so that would be considered what's called a non-economic damage. But there are also extra contractual consequential economic damages. So as an example, if a homeowner is forced as a result of the insurance company's conduct to go and purchase another home or to go and rent another home, those extra contractual consequential claims can be made against the carrier. Attorney's fees are a form of consequential economic loss because but for the insurance company wrongfully withholding the funds, you wouldn't have had to hire a lawyer, but you had to hire that lawyer because of the insurance company's conduct. And so you can make a claim for certain attorney's fees pursued to recover contractual benefits as part of the bad faith claim. And then there's a third category that can be available in certain unique circumstances where the insurance company's conduct is malicious, oppressive, or fraudulent. And that would potentially trigger a right to punitive damages, which are different than those that we described before. Unlike those before where you're compensating the policyholder for what has transpired to make them whole for their experience, punitive damages are there to punish the insurance company or any sort of defendant who acts in a malicious, oppressive, or fraudulent manner. And that is a whole nother story for a whole nother conversation. But just to show that there are different remedies available other than simply the contractual benefits that we've been talking about.
Thank you for outlining that. So what I'm hearing is it's really important to keep a log of your experience and your interaction with your insurance company. Stay off the phone, try to do emails, so everything's documented. And if you do take a call from your insurance company, I understand that it's important to do a follow-up email to outline what it is you spoke about and covered in that conversation. Do I have that correct? I'll throw that to James.
Yes. Anytime you have a phone call with your adjuster or anyone else out of the insurance company, just send a short phrase. It doesn't have to be super formal, but send an email confirming what you guys talked about, what promises they told you, what sort of deadlines and timelines they provided to you. Because when you send that email, it ends up in the claim file. And down the road, when you're in litigation, we are then able to point to that specific email in the claim file and say, look, they knew about this. They promised this and they didn't do this. And so those are the biggest piece of advice is document everything on your own and then send that follow-up email to the insurance company confirming anything that they told you. And if you submit a written report, follow up with them. Say, I submitted that report 2 weeks ago. Just want to confirm you received it. Let me know if you have any questions. What other information do you need from me? And that repeated sort of documenting the file, it's going to help your lawyers down the road when they're trying to make the case that the insurance company's been completely unreasonable, which will entitle to you to sort of all those different buckets of damages that Kevin was talking about.
Okay. Thank you. So that completes our preset questions. And now I will pass the moderating over to Jessica, who's going to cover some of the submitted questions that we received ahead of time, as well as some of the questions in the chat. Take it away, Jessica.
Thank you. I think this has been answered, but just so that we can kind of have it out there again, can you explain the statute of limitations which apply here? So when is the latest that someone can file a lawsuit?
I think that the general, everybody's claim is going to be different, right? So to Dylan's point, you should consult with somebody about your specific claim. But generally speaking, under Insurance Code 2071 for a residential claim, one typically has 12 months to file a lawsuit. But in the event of a declared state of emergency, that's extended to 24 months. Now, one of the things that California law provides is that once a claim is opened and is being adjusted, that statute stops. It's what's called is tolled, meaning the clock stops ticking while the claim is open and being adjusted and being investigated, and then the clock would start ticking again when the insurance company, issues its final payment, denies further benefits, etc. Obviously, you can ask those questions of your insurance company. They're actually required to tell you that information. But to Dylan's point earlier, while the statute may not be coming up for many people because their claim has been open, it's being investigated, they potentially have up to 24 months. Regardless, there may be ripe claims to bring against the insurance company, now. Waiting isn't going to necessarily be helpful, assuming that you've already been doing the work needed to present your claim. Because as Dylan pointed out in the very beginning, the homeowner's job is to present their claim, exhibit the damage, and once they've done that, presumably in these types of cases, by getting the evidence they need to show they have a loss, by getting the testing that they need. Right? If you haven't gotten that testing yet, that's something that you may want to consider doing. But if you've done all those things, there's no reason to delay getting legal counsel because lawsuits take time.
Let me also just add one point to what Kevin said, which in terms of your timeline. There are a remarkably small number of lawyers in California who practice in this area and who specialize in it. It is a surprisingly small number. We all know each other. We all like each other. We get along great. Not a lot of competition, but it's a very small number. And that means, especially after these fires, that there is an immense burden on our firms. And while obviously we're going to be doing our best to assist all we can, it behooves you to start investigating, doing your due diligence, talking to lawyers now, because this is very different than sort of like in the personal injury world where lots of people have billboards and so forth. This is a pretty small practice area. So you are going to want to get on the horn and start talking to people and figure out the right fit for you, because there's a lot of competition for the resources and will be for the next 5 years.
So while litigation is pending, are insurers required to reimburse ongoing expenses such as rent, mileage, storage, and testing fees, or does recovery only occur after judgment or settlement?
As a practical matter, should they continue to pay your ALE? They should. Will they? Not necessarily. as a practical matter, once you file the litigation, the insurance companies are going to be a little bit hesitant to do anything because they're going to be more concerned about how it affects the litigation. And another good thing about litigation is, you have these insurance companies these adjusters who they know that their goal is to pay as little money as possible. And when you file a lawsuit, all of a sudden they have to go out, the insurance company has to go out and hire these relatively impressive lawyers to defend your claim. And those lawyers are going to look at your claim brand new with fresh eyes. And they have some skin in the game because trial lawyers don't like losing trials. So they don't want to deal with a piece of litigation that they can't win. And so they do their own first write-up of the claim. And I did these for a long time for insurance companies. And it's a significant report. And it includes, the dangers of going all the way to a trial, recommendations as to settlement amounts. And that type of workup is another chance for somebody to look at the file and really come to a conclusion that you should be paid sooner rather than later to cut off all of those economic damages and potential for attorney's fees and punitive damages. So filing a lawsuit gets you that benefit as well. You're sort of getting a fresh set of eyes on things that can be very helpful. And there's on cases that I filed, within a month, 2 months, the insurance company's lawyers are coming to us and asking for settlement demands. So it really does behoove you to sort of take that step. Getting back to the original question, which was, are they going to keep paying for things and reimbursing things? Realistically, all your sort of communication with the insurance company once you hire a lawyer is going to go through your lawyers anyhow. And once we file litigation, we're not talking with your adjusters anymore. We're only talking with the lawyers, and we can submit stuff to them. But at no point are we really expecting that, that they're going to issue a check for a couch or, what we're doing is we're making a giant record to get you paid as much money as possible for your entire pool of damages. So, and I know all of us are pushing these insurance companies as hard as we can with discovery, depositions, et cetera, to force them to come to these sort of inflection points where they know that they either have to pay you or they're going to try the case. And so you really want to do sort of, I don't see much of a downside at all to really sort of pursuing the litigation aspect as soon as possible, because that's going to get you your recovery for all those sort of little expenses into a big pool sooner rather than later.
Thank you. Going on to remediation, we had a lot of questions about post-testing. Are insurances supposed to pay? And if so, is there limit amounts in what they are supposed to pay? Do they only have to test for lead? Are they required to test for anything else? Kevin?
Well, as Dylan pointed out earlier, they're required to thoroughly investigate the claim to bring the property back to pre-loss condition. So, in my view, the testing that needs to be done is what we know now is that there are various contaminants as a result of fires like this. And so there needs to be thorough testing to ensure that the home is safe and can be brought back to pre-loss condition. And if the insurance company is pushing some limited testing, then that is inappropriate and wrong in my view.
Thank you. Do industrial hygienists bear any liability for the recommendations that they make in their reports?
A lot of times you'll see disclaimers in their reports, that they're simply interpreting the data as pursuant to the standards. In the cases that I pursue if the hygienist has been retained by the insurance company. They're acting as an agent for the insurance company. And so, if the insurance company is relying on their recommendations and the recommendations are wrong, you can pursue those claims against the insurance company.
Thank you. Can you compare what happens when working with a public adjuster versus an actual law firm? James?
Yeah, I think working with a law firm, it just gives you, so all of us, a public adjuster, they are great at sort of cataloging your losses, communicating with the insurance company for you, but there's no real teeth to it. And so in my sort of experience, I have people who have worked with public adjusters, for the last 9 months, and they've gotten really nowhere. I'll be honest, even when the lawyers write letters and sort of complain about, different aspects of testing, and we're going to sue you by next Thursday if you don't sort of give us the report and remedy all these things that you've done, a lot of times they don't do anything. It's the same thing. So unfortunately, in sort of working with the public adjuster, they're great at sort of cataloging things. And sometimes, there's vendors who will use to help with that cataloging process to use in the litigation as well. And so there's a lot of overlap, but there is sort of not a lot of teeth to what a public adjuster can do. And a lot of times your public adjuster is going to get to the same point that you would and say, they're not even in the insurance company's not even in the right scope, world, universe of what needs to be done. And they're just recommending that you hire lawyers. So I think where you're going to end up, whether you sort of hire a public adjuster to sort of pursue things and make things your life easier and having to deal with the insurance company and take that communication aspect off your plate, it saves you that sort of hassle and the pulling your hair out because the public adjuster is doing that for you. But you're going to end up where most likely you're going to need litigation if you really, really want to pursue every dollar that you're entitled to under the contract.
Yeah, let me just add to that. I think that like anything else, there's really good public adjusters, and then there's really some not good ones. Just like there's really good lawyers and some not really good ones, or dentists. But I think public adjusters serve a really fundamentally important purpose on smoke losses in particular. In what we're facing from these fires, I think ultimately a lot of people are going to require legal counsel to get the recoveries that they need. But there's absolutely a place for public adjusters. Maybe, if people retain public adjusters early, to James's point, they're great at getting hygienists, getting, a content specialist, documenting, the damage for sure. But public adjusters are not lawyers. They cannot engage in the unauthorized practice of law. And so there are certain things, to James's point, that they cannot do. But each claim, each situation is different. And, there's some really sophisticated public adjusters out there who are really adept at writing good letters and putting together strong claims that, if litigation then is necessary, public adjusters have referred cases to me and have done a great job at documenting that file and have absolutely brought value, for my clients.
We have a lot of questions about contents and in terms of like itemized receipts. Is there a dollar limit as to when receipts are supposed to be submitted or not submitted? I don't know if anyone has the answer to that. Maybe Dylan?
Yeah, you said dollar limit and then you said timeline. So two different things. There's typically stated limits in insurance policies for contents recovery, and those limits are useful to know. So you want to keep your eye on those. And then typically there are timelines that apply to recovery for contents and also recovery for replacement benefits if you're going to actually replace items that you're tossing. So you do want to be aware of those. if you just asked your carrier what those limits are in terms of the timelines, they are obligated to provide guidance on what the timelines are. They're very different under different policies. So you just want to ask your carrier.
Thank you.
Let me just add to that. I know that there have been situations recently where carriers are issuing payments without an itemized list for a portion of your contents claim. And I think that for many people, that lulls people into a safety blanket of not going ahead and preparing the inventory. And the problem that I then see in litigation is when there is money still left on the table, meaning, they feel that not all of their contents have been paid for. They don't have that list. And as a lawyer, without evidence, I can't make a claim. So I think it's really important for people to do the exercise of going through and filling out an inventory, working with professionals, whether it's lawyers, public adjusters, or hiring contents consultants, to do that exercise. Because in almost every single case that I've ever been involved with, people forget about various items, right? Even a toothbrush has value. And so there are things that people will forget about, or by not doing that inventory when it's fresh in their mind, it becomes that much harder to then go back and recreate things after the fact.
The list or picture sufficient, or do they need to keep the content until the claim is resolved?
No. So, I mean, as an example, like in a total burn down, right, where the content is no longer available because it's been incinerated, a list, photographs, there's no requirement under the policy or under California law that there be any one type of evidence to support it, right? A homeowner's testimony in a documented form or otherwise will suffice to the existence of that item. And then there can be, an investigation into the value. If the homeowner has a photograph, then great, right? Then that's going to be, amazing evidence. But if they don't have a photograph of it, that's okay too.
Thank you.
Just one quick sec. I have questions all the time, but I don't have a receipt for that. It doesn't matter. Put it on your inventory. Nothing requires a receipt. So if you have one, fantastic. If you can find the same item on Amazon, take a screenshot and save it to a folder. So certainly don't not include things because you don't have a receipt.
Thank you. If someone was to join a lawsuit against Edison and also have a lawsuit against their insurance, does that affect them? A lot of people are hearing that if they receive any monies from suing Edison, they have to use that money to repay the insurance companies. Can you give a little bit more insight into that, Kevin?
To repay the insurance company? I don't know. I mean, I've been involved in a whole host of different scenarios. In the 2017 North Bay fires, when PG&E was sued, I represented people that simultaneously pursued claims against PG&E as well as against their insurers. The same thing from the Woolsey fire, et cetera. In my view, they're different claims and they have different primary rights. Particularly when you're talking about, bad faith claims handling. And so I couldn't say, about having to pay a carrier back. I know that insurance companies often do what's called subrogation, where for the monies that they pay, they turn around and they may sue a third party who was responsible for causing the fire. And the insurance company will seek recovery of those monies from that third party. But, to me, I think people should consult with lawyers and pursue righteous claims. And if you have a righteous claim against an insurance company, you should pursue it if that's what you and a lawyer decide, makes sense to do. And if you simultaneously also have a righteous claim against a third party that started that fire, then you should consult with lawyers about that as well.
Thank you. Jane, we are at 8:28. Do you want me to continue or wrap up?
Oh, goodness. Boy, this is so hard. You guys have, I know there's so many questions and people really want to hear more, but I also don't want to keep these gentlemen longer than we promised. And it is a Sunday evening. And they were kind enough to put their time aside over the weekend to meet with us. So what I'll say to folks is if your question was not fully answered, sorry, we do want you to be able to get the answers that you need. I would encourage you to perhaps reach out to any of these three. I know that they are open to discussing potential new clients' concerns, and perhaps we will have them back at a later date. Thank you. Thank you so much, Dylan, Kevin, James, for your time, for your insight. I'm a loss, honestly. You guys have answered quite a few questions and unraveled some of the mysteries we've had around what to do next. And this has been an incredibly informative event. We will be posting this recording to our website at www.efru.la. You want to go to the resources tab and then look for EFRU videos. Within that, you'll then see speaker events. If you are not part of our newsletter, we'd love to have you join us. You can email us at eaton.fire.residence.united@gmail.com. And you just put in a request that you would like to be added to our newsletter. We do send it out every week. And we do let people know when new videos are posted to our website. Thank you. Thank you all panelists for coming tonight. And I wish everyone a safe night. Take care, everyone.